becoming more and more digitized now. And this digitalization has made the flow of information very readily available. So on one hand, we have this facility that the information which was previously some 20 years back, which was previously not so easily available, is now very much available to the users all over the world due to the internet, due to the information technology, due to the digitalization of the information. But at the same time, there comes the challenge of securing our information, protecting our information, because when information is available to the whole world, there is always a possibility that information breach can take place. At the same time, we need to understand very importantly that what basically is a patent. So that Mr. Arpit Jain will be telling us today. He will be briefing us about the patents, types of patents, and how we can file it. And as far as at the same time filing, and not only filing but also protecting the valuable information of the project or the innovation or the article or any new thing which we have written or created or done. So it is very important in today's digital world to understand that the digital information which has been presented by you, which has been posted by you, which has been uploaded by you on the internet remains protected. And anything which you do which is a unique in its sense, have a different outcome than the till then present outcome, needs to be patented, needs to be copyrighted. So patent becomes important. Not even previously we used to think that if anybody has done some very big experimentation work or very big research work, then and then only he or she should go for the patent. But it is not like that. Even a small work which is done by a student or a group of students or a faculty or any individual or a group, which can be patented, which has that stuff which can be patented, which is different from whatever has been done till now, that can be sent for the patent.
Sir, का photo आ रहा है क्या picture?
So I
I'm not able to. Namit ji, I'm not able to see your picture.
But my video is on.
आप लोग देख पा रहे हो?
Sir is visible, sir. Sir, Namit sir is visible.
How come I am not able to see? Okay, Namit ji, please continue.
Yeah. So the purpose, the sole purpose of this whole mission is, and the sole idea of this awareness program is to make the students aware that whatever technical work or any other work which they are doing in their graduation days or post-graduation days, or else otherwise also, if it is having some element of newness, if it is having some element of invention, then definitely that information can go for a patent. So we have Mr. Arpit Jain with us from NIPAM, and I welcome him once again, Arpit ji. And I hope that this webinar will be very helpful for a student participant, because as Supriya madam was telling us that we have more than 200 plus registrations, and I can see already around 60 participants have joined this session. So we hope that 200 plus students will be benefited by this particular webinar of today. So thank you very much, and once again welcome to the speaker. Thank you.
We are very pleased to have with us Engineer Arpit Jain, Examiner of Patents and Designs, Patent Office, Mumbai, DPIIT, Ministry of Commerce and Industry, as a key speaker. Welcome, sir. Moving right along, I invite Professor Samiksha Bhatt, Assistant Professor, Sri Vaishnav Institute of Architecture, to introduce our speaker.
Thank you, ma'am. This is privileged to introduce Mr. Arpit Jain. Mr. Arpit Jain is working as Examiner of Patents and Designs at the Patent Office, Mumbai, Government of India. He primarily deals with examination of application field for patents in the field of electronics and telecommunication engineering. He is the editor of IPR newsletter for the Office of CGPD-TM. He is also working on enforcement aspects of IPR and patent agent examination to be held in May 2022. He has completed Bachelor's of Engineering in the field of Electronics and Telecommunication in 2015 from IET DAVV, Devi Ahilya Vishwavidyalaya, Indore, Madhya Pradesh. He completed his higher secondary education in 2011 from Sri Krishna Memorial School, Guna. He has completed high school education in 2009 from People Public School, Bhopal. His hometown is Binaganj, District Guna, Madhya Pradesh. Thank you. Welcome, sir. Welcome. Over to you, ma'am.
Thank you, ma'am. Participants will have the opportunity to ask the questions to today's speaker by typing your question in chat box. The question answer section will be at the end of the presentation. Now, without any further delay, I invite Engineer Arpit Jain to address the gathering. Welcome,
Thank you, ma'am. Thank you for providing the opportunity to the students and faculty members about the session regarding the IPR awareness. We start the session now. So my screen is visible.
Yes, sir.
Yes, sir.
So whenever we talk about intellectual property rights, they are the rights they result from the activity, whatever intellectual activity you are doing in the field of industrial research or scientific field, or you can say literary work, artistic fields like painting, drawing, sketching, etc. Intellectual property rights, they are like any other property rights. They allow the creators or owners. Who are the creators or the owners? First of all, we need to know about that. Say 5 students of Vaishnav College, they have designed something, they have made something new, some instrument, or you can say some invention they have done. So they are the creators. They are the creators. They are the owners of that creation. So whenever we talk about intellectual property rights, they are like other property rights. They allow the creators or the owners of patents, designs, copyright, trademarks to benefit from their own work or investment in a creation. Since it is said that a person who has invented something, he is the owner of that thing. Okay, so that's why they are the owner and they can benefit from their creation. What is intellectual property? Intellectual property is something that is, you can say, creation of ideas and then expressing it. Say 5 students or say 3 students of Vaishnav College, they have some idea in their mind.
Mr. Jain, your screen is not, slides are not moving. Are you moving the slides?
Some slides are moving or not?
No. No.
No, sir, not moving.
Okay, I will share once again. Just a minute. Are they moving now?
Yes, sir. Now,
Yes.
Fine. So intellectual property rights, they are like your other property rights. They allow the creators of or owners of what? Of the intellectual property like patents, trademark, copyright, or designs to benefit from their work because they are the creator. So they are the owner and they have all the rights to benefit from their creation. IP means what? Intellectual property means what? Creation of some ideas. Say some student has some idea in a mind, some creation he or she want to do. So that is the idea in the mind. Now, whenever he or she expresses that idea in the form of, you can say in a physical form, then you can say it is conversion of intellectual property into a physical property. So intellectual property means creative ideas and expressions of human mind. That is, you can say, creation of mind. Creation of mind is called as intellectual property, and that will be having some commercial value. Say one student is having an idea to develop some model of car. Fine. That idea, once he realizes in the physical form, say he made a car, now that car has a commercial value. So that is how we can say intellectual property is something that is creation of human mind and that is having some commercial value. Intellectual property is just like your any other property. Just like we have physical property in our home, you can say our home, our gold, or you can say jewelry, whatever we have, physical property, you can sell them, you can buy them, you can license them, and you can exchange them. In the same way, intellectual property can be sold, bought, exchanged, or you can say licensed to some other person. Say one student has designed some model, fine. So the institute can license it to any other industry or any company. So that is a way. Intellectual property, just like any other property, you can sell it, license it, or exchange it, or you can buy it. Imagination is more important than knowledge. Why it is said imagination is more important than knowledge? Because just think about that Nokia 1100 phone. If we think about that Nokia 1100 phone only, then we cannot have smartphones, or you can say these phones that we have today, that variety of phones we are having today, because somebody was thinking beyond this Nokia 1100. And this is called as thinking beyond existing knowledge. You have to think beyond this existing knowledge. Whatever the published material is there, you can say your books, your research papers, your journals, they are all published. These are, you can say, they are the existing knowledge, and you have some problems. So you think beyond this existing knowledge and you can imagine how to solve your problem. Okay, how you develop new concepts? New concepts are developed based on the existing concepts. Okay, so you think beyond this existing knowledge, you create something, you innovate, and you create an intellectual property, and that intellectual property is the solution to your problem. How we create intellectual property? You have some resources. Say one student is there and they are creating some model. Fine. They will read some resources. Yes. They will take the guidance, or you can say the mentorship of some faculty member. These are called as resources. What is brain? They will apply their mind over that resources, and they will put their hard work and time, and that is called as labor. All these three things when combined, this is called as intellectual property. Why we need to protect IPR? Just like in the introduction, sir has said, Dr. Namit Gupta said about why we need to protect. Because there are chances that your invention, your model, your instrument can be stolen by any other third party. The world is competitive. And also there is a possibility that two same minds are thinking in same direction. Say one student of, you can say one student is there in Vaishnav College, he is thinking some way. And on the same line, somebody is also thinking in other part of world. So two minds in the same world can think in same direction. So that's why those who register it first, they get the right. That's why it is said that there are chances that your creative ideas can be stolen, or somebody is also thinking in your direction. That's why you need to protect your intellectual property. Technologies are changing rapidly. You can say in some fields, technology are changing, you can say in minutes, seconds, hours, like that. So technology changing rapidly, and there are chances that your creative ideas can be stolen by third party. So you need to protect them. And that's why it is said you should register your intellectual property. What is the advantage of protection? Once you protect, so you get a certificate from Government of India, and that protection excludes the whole world, because it is your property now. It is your intellectual property, it is your patent, it is your design or your trademark or your copyright. Now nobody else can use it without your permission. That's why it is said, once you register your IPRs, you exclude the whole world. And now you can utilize it, you can commercialize it, and you can earn from your creation, your patent, your design, your trademark, or your copyright. There are two types of rights associated with intellectual property rights. One is moral right. The fruits of a man's labor belong to him. Why it is said like this? Because say one student is there in Vaishnav College, he invented something, or he or she invented something. So since they have put their hard work, all the moral rights belong to them, and also the commercial rights arising out of that invention, or you can say copyrighted material, they belong to them only, because they are the person who created that invention or that material. Fine. What are the types of intellectual property? Patents. Whenever we talk about patents, patent is a kind of intellectual property that is granted to inventions only. Inventions, you can say in Hindi, avishkar. Patent sirf avishkar ko hi milta hai. Patent is granted to inventions only. If you are creating some model, you can say you are inventing some model, some instrument, some device. Okay, patent is granted to that invention only. When we talk about design, so you can say for the technology part of this phone, There's a phone in my hand. For the technology part of this phone, you can register for patent. Design is called as outer appearance of any object. Outer appearance maybe my headphones are there, or you can say I have mouse, or you can say this phone, the back cover of this phone. Design is all about outer appearance. Nobody is worried about your construction or principle of construction or technology. Design is about outer appearance, the aesthetic aspect. What are the aesthetic aspects? One is, you can say, pattern, size, color, configuration. These are called as outer appearance. So जब हम डिजाइन की बात करते हैं, डिजाइन इज बाहर से कोई प्रोडक्ट कैसा दिखता है, कलर, शेप, साइज, कॉन्फ़िगरेशन, लेकिन वो कैसे बनाया है, वी आर नॉट वरीड अबाउट दैट. That's why design is said as aesthetic aspect or ornamental aspect of any jewelry article might be there, any device. Say this is the you can say AC remote is there. The outer appearance of this AC remote can be registered as a design. Fine. As a design registration can be done for the outer appearance of any object. Whatever, a glass may be there, a jug might be there, a pen might be there, whatever. But for the technology part, for the invention part, you have to register a patent. So you can see, for a single phone, you can have 2 intellectual property registration. For the technology part, you can register a patent, and for the outer appearance part, you can register for design. What is trademark? Whenever you are opening a business, you will always want your customer should know your product by some name. And when you want that your customer should know your product by some name, you will always think, yeah, my logo must be attractive, my slogan must be attractive, my name must be attractive, my name should create a sensation in the mind of customers, my tagline, my slogan जिंदगी के साथ भी, जिंदगी के बाद भी, it creates a sensation in the minds of customers, those who are looking for insurance. It is LIC tagline or slogan. Okay, so these things are registered as trademark. For example, you can always think about, like, Britannia is there. Britannia having a sound mark, ting ting ting, that is a sound mark. Companies also register their sound mark. Or you will find a lion roaring. Whenever you see some cartoons on Cartoon Network, some serials, they have that what? They have some inaugural, you can say, sound tone is there. Lion is roaring. Okay, and that is the trademark of Metro Goldwyn Mayer. A company is there who is producing that serial. So these things come under trademark. You can say brand name might be there, a logo might be there, or sound mark might be there. In some countries, smell and scents are also registered. Not in India, but in some countries. Geographical indication, what are they? Geographical indication, you can say in very simple words, geographical speciality of a region. Ratlam, Ratlami Seo, Agra Petha, Kashmir saffron, Goan cashew fenny, Nasik grapes, Nagpur oranges. These are the variety that are found in that specific region only. Or Chanderi sari, Bagh prints of the Dhar district of Madhya Pradesh. These all things are geographical speciality of region. And इनको हिंदी में बोलते हैं भौगोलिक उपदर्शन. ये उसी जगह की पर्टिकुलर विशेषता होती है. These are the, you can say, speciality of that region only, and that's why they come to Government of India and they say register our intellectual property in the form of GI tag, because they are the creator of that property. There is a cultural heritage that is associated with that area only. वो वहीं पे होता है और कहीं नहीं होता है इंडिया में. It is happening in there only. That's why it is said as geographical indication. किसी geographical location की कोई विशेषता है वो. हो सकता है, it can be a farmer produce, it can be artistry work. So these things are called as geographical indication. Now coming to copyrights. What is copyright? Whenever you will do Google and you will search the definition of copyrights, it is said protection of original authorship. What is this protection of original authorship? Somebody has written a book. Who is the owner? That person. That person is the author of that book, and the person is the owner of that book. Okay, so protecting the original authorship of that book. The content may be what? A literature work. Say Literature work includes what? Books, newspaper, any faculty lecture might be there. It can be reduced to a writing. Computer programs, computer software, all these things, or your question papers of examination, these things come under literature work. And literature work are registered under copyrights. Whenever we talk about artistry work involves painting, sketching, drawing, engineering drawings. Okay. So these things come under artistry work. And also cinematographic works like films, music, sound recording, sound mixing, all these things come under copyrights. So now you know a basic difference. ऐसा ना हो कि बाजार में और लोग बोलते हैं आप भी वैसे ही बोलें कि यार मैंने ना किताब का पेटेंट करा लिया. नो, किताब, a book, it is a literature work. Literature work is registered as copyright. For the software programming inside this phone, software codes, program, or music, or the user manual with this phone, all these things are literature work. They will be registered as copyrights. But for the technology part, you can file a patent. टेक्नोलॉजी, तकनीकी क्षेत्र के लिए आप टेक्नोलॉजी के लिए आप पेटेंट फाइल कर सकते हैं. इस फोन में जो भी प्रोग्राम्स हैं, म्यूजिक है, साउंड रिकॉर्डिंग्स है, साउंड मिक्सिंग है, उन सब के लिए, या इसके साथ एक किताब आती है यूजर मैनुअल. देयर इज ऑलवेज अ यूजर मैनुअल विद इलेक्ट्रॉनिक डिवाइस, एंड दिस यूजर मैनुअल लिटरेचर वर्क इनसाइड दैट डिवाइस कैन बी रजिस्टर्ड एज कॉपीराइट्स. हाउ द फोन इज लुकिंग फ्रॉम आउटसाइड, द आउटर अपीयरेंस ऑफ दिस फोन, उसके लिए आप डिजाइन रजिस्ट्रेशन फाइल कर सकते हैं. इफ यू वांट टू ओपन अ ब्रांड फॉर दिस फोन, यू कैन हैव अ ट्रेडमार्क. You can see the beauty of intellectual property. Actually, it is a beauty of intellectual property that there is a single property, a single physical property is there, but there are 4 intellectual property associated with it. For the technology part, you can file a patent. For the outer appearance part, you can file a design. For branding of this phone, you can have a trademark. For literature work inside this phone, you can have a copyright. Coming over the last intellectual property that I am discussing, semiconductor integrated circuit layout design. The students who are from computer science and electronic background, they might be knowing about this IC term. Many of your electronic devices, they contain ICs inside them. And what happens, one company developing one IC, fine, or one researcher or one student, they have designed some IC, but there are chances that IC can be opened. दुनिया में लोग बहुत शातिर हैं. They can open the IC also, and they can see the internal structure of your IC, the layout of your IC. That's why the ICs, if you are designing some IC, you can register that IC layout also. That is the way to protect your IC. So whenever company or a researcher develops a new intellectual, you can say new IC, integrated circuit, they register it so that no one else can copy. No one else will copy their IC layout. Now, session is about patents filing and protection. We will discuss patents in detail. This is a simple example that how a single physical property is there, a laptop, but you can find all the intellectual property inside it. For the Apple with a cut mark, you can have a trademark, fine. For the technology, LED display, you can file a patent. For the outer dimensions of this laptop, the appearance, the length, width, height of the screen, whatever, for all these things, you can file a design registration. For a user manual or the computer programming part, you can file a copyright. And for the ICs inside this laptop, you can file SICL design registration, semiconductor integrated circuit layout design registration. This is the beauty of intellectual property, that a physical property is there, but all 5 intellectual property are hidden inside it. Patents. Patent is one of the oldest form of IP protection. Patent system start हुआ था 1700s में. Patent system started in 1700s. And why government is giving you a patent? Just think about it. If you are developing something and anybody else can copy your invention, then you will not be encouraged to do more innovation. अगर आपने किसी मॉडल को डिजाइन किया है, just think करिए, मॉडल आपने डिजाइन किया है, but कोई भी दुनिया में आपके, you can say, आपका दोस्त अगर easily आपके इन्वेंशन की नकल कर सकता है, बाजार में बेच सकता है, तो आप क्या और इन्वेंशन करेंगे? नो, यू विल नॉट बी एनकरेज्ड टू डू मोर इनोवेशन. दैट्स व्हाई इट इज सेड यू शुड प्रोटेक्ट your intellectual creativity, and the government rewards you. For the patents, you get 20 years protection for your invention. 20 साल तक अधिकार पूरे आपके पास होते हैं अपने आविष्कार के, and that's how 20 year protection आपको मिलता है. 20 year protection मिला है आपको, आप उसमें अपने प्रोडक्ट इनोवेशन पे जितना आपने वर्क किया है सालों से मेहनत से, you can create a whole industry on that. Okay, you can realize commercial benefits out of that. तो इसलिए आपको 20 साल के लिए ये अधिकार मिलते हैं. एंड एनी इंटेलेक्चुअल प्रॉपर्टी राइट प्रोटेक्शन, चाहे आपको कॉपीराइट का प्रोटेक्शन मिल रहा हो, चाहे आपको ट्रेडमार्क का प्रोटेक्शन मिल रहा हो, ये क्यों मिलता है? इसलिए मिलता है क्योंकि उस इंटेलेक्चुअल प्रॉपर्टी के लिए आपने मेहनत की है. यू वर्क फॉर इट फॉर इयर्स, एंड दैट्स, if you are not getting protection, then you will not be encouraged to do more innovation. अगर आपके सामान की या आपके आविष्कार की कोई इजीली नकल कर सकता है, से आपके किताब की कोई इजीली नकल कर सकता है, तो आप मोटिवेटेड नहीं होंगे. You will feel demotivated. There will be a disc in, you can say, you will not be encouraged to do more innovation. That's why governments rewards you by giving you a certificate, by giving you by giving protection to your intellectual property, by giving you a certificate of patent or design or copyright. Now coming over patents, what we check whenever you file for a patent application, there are 3 things we check. One is novelty. Dr. Namit Gupta has discussed newness. That newness is called as novelty. आप ये सोचिए, whatever you are doing, अगर आप वर्तमान में जो चीजें बनी हुई हैं, अगर आप वही चीज वापस बनाते हैं, उसका कोई सेंस बनता है? No. You should create something, some device, some instrument with new features, and that is called as novelty. The novel features, the new features, the newness in your invention. Second thing is inventive step. Inventive step means non-obviousness. आपने जो बनाया है, whatever model or invention you have done, ऐसा ना हो कोई इसकी easily नकल कर ले. ऐसा ना हो कोई इसको easily produce कर पाए. Means say you develop something, but एक चलता फिरता आम आदमी भी अगर उसको बना दे, it is not called as, you can say, it will not get patent because it is obvious. आपने जो भी बनाया है, it should not be obvious to any other person. Fine. Your invention should be non-obvious. That is called as inventive step. Your invention should not be obvious to any other person skilled in the art. ऐसा ना हो जो आपने आविष्कार किया है, उस आविष्कार को कोई चलता फिरता इंसान भी कर दे. No. Your invention should be novel. First thing, it should have new features. Fine. Second thing, inventive step, it should not be obvious. It should have the you can say the speciality of non-obviousness. And the third thing is industrial application. आपके आविष्कार की इंडस्ट्रियल एप्लीकेशन भी होनी चाहिए. अगर आपने कोई ऐसी चीज बनाई है, it is not industrially applicable, it is of no use. That's why you need 3 things in your invention: novelty, the newness, inventive step, non-obviousness, and third thing is industrial application part. These 3 things are checked whenever you file a patent application to the patent office. Okay, these 3 parameters are checked, and how we check these parameters I will explain you in the next slide. First of all, let us have a, you can say, a distinction, or you can say a difference between invention and discovery. America was there, gravity was there, plant cell was already there. पहले भी एप्पल नीचे गिर रहा था, ऊपर नहीं जा रहा था. These things were already existing and somebody discovered them. This is called as discovery. Whenever something is already existing and you discover it, you find it out and you say to the world, this is something like America or gravity or plant cell. These things are called as discovery. But whenever we talk about invention, invention is something that is new. That newness, novelty part, non-obviousness part. Telephone was a new thing when it was invented. Light bulb or computer, these things were new. They were not obvious. They were having non-obviousness feature, and they were having industrial application. उस जमाने में भी उनकी इंडस्ट्रियल एप्लीकेशन थी और आज भी है. So telephone, light bulb or computer, they were not already existing. They were created new by some inventor, Graham Bell or Edison or Sir Charles Babbage. So these things were newly designed. That's why they are called as invention. Coming over to the, you can say, the legal definition of patent. You can find it here. A feature of an invention. जब आप application file करते हैं ना patent की, तो उसमें 3 चीजें देखी जाती हैं, और वो कानूनी भाषा में हम लोग क्या बोलते हैं, देखिए. A feature of invention that involves technical advancement as compared to existing knowledge. जो भी existing knowledge है, उसके ऊपर कुछ होना चाहिए. The newness, the novel part, technical advancement must be there in your invention. अगर आप वही चीजें बना रहे हैं जो already existing है, it is of no use. अगर आप एक नोकिया का फोन है and you are just changing its color, it is not giving any significance. Okay, so there should be some technical advancement as compared to existing knowledge, or having economic significance. Your invention should be industrially applicable, and your invention should not be obvious to any other person skilled in the art. It should have the feature of inventive step. Inventive step वहां पे होनी चाहिए. You can see the first Indian patent was given for an efficient पंखा pulling machine. याद करिए वो जमाना जब पंखा पुलिंग मशीन की जरूरत पड़ती थी. आज आप एक स्विच से फैन को ऑपरेट करते हैं, and now you have a better version. You can operate your fan by just you can say by your smartphones. We say the concept as smart homes. Fine, the IoT concept. So you can say that somebody is thinking about innovation. नई चीजों का आविष्कार तभी हो रहा है जब मानव को लग रहा है कि वर्तमान में जो वस्तु का वो उपयोग कर रहा है, it is not adequate, वो sufficient नहीं है. That's how innovation culture happens. So whenever you are working on your projects, जब आप अपने projects पे work करते हैं in your engineering, okay, you should always think in the direction that you create something new over the existing technology. There might be some Michael Jackson fans here. Michael Jackson did a tilt in dance, that 45-degree or inclination he was able to do, not because of the flexibility in his body. It was due to the invention in the shoes. उनके shoes में you can say there was something that one part got stick to the surface, and then other part is having the flexibility to move. So that's how he created balance, and he was able to have a tilt. And Michael Jackson got a patent for his invention in shoes. Michael Jackson and Michael L. Bush, they both got the patent, okay, for this invention in shoes. और आपने देखा होगा और किसी आर्टिस्ट के पास ऐसी you can say ऐसा, they are not using such type of shoes, or they are not able to do this type of tilt because Michael Jackson का patent था. Nobody else can use it without his permission. That is the power of patent. 20 साल के अधिकार होते हैं आपके पास. 20 साल तक उस आविष्कार का उपयोग आपकी परमिशन के बिना कोई नहीं कर सकता. Nobody else can use your invention or derive something out of it without your permission. That is the power of patents, and you should get that protection. Why? Because you are the person who created it. हो सकता है आपने उस invention को करने में सालों लगा दी हो. Some people in engineering, they work for 4 years on a single thing and they create something new. So the people who are working on their projects or workshops, you should always think to design something that is not existing. You should create new things. Fine. पेटेंट एप्लीकेशन फाइलिंग. जब आप पेटेंट की एप्लीकेशन को फाइल करते हैं तो आपके 5 फॉर्म की रिक्वायरमेंट होती है. देयर आर 5 फॉर्म्स रिक्वायर्ड. वन इज फॉर्म 1. फॉर्म 1 contains your basic details, where what is your address, your correspondence. If you are developing a model of, you can say, a phone, you can say there is a title is there. So title, you can say your address, your email address, your nationality, all these things are part of form 1, basic details of your application. Okay. Form 2, आप अपनी project report बनाते होंगे, and how you create your research papers. You will discuss the background art. अपने background art को आप discuss करेंगे. What is already existing? दुनिया में अभी क्या already existing है, and what is the technical advancement I am doing. These are the part of your form 2, and that is called as complete specification. You will explain the background of invention, what is the existing technology, and how you are doing technical advancement. You will use some drawings, you have some numerical analysis, some tabular analysis you will be providing to us so that we can understand your invention better. Abstract, a basic summary of your invention. You will be providing some drawings. Also, there is something called as claims. Claims are the important features of your invention. Say you submitted a 50-page specification. You have 50 pages in Form 2. Fine. But out of that 50 pages, there are some important features and that are called as claims. Say you developed some device. You will say a device for so and so. A device comprising a memory, a processor, a interface, whatever. These things, the important features are listed as claims. And how you write that claims? You take the important features out of your specification. जो भी आपकी स्पेसिफिकेशन है उसमें से जो इंपॉर्टेंट फीचर्स हैं आप उनको क्लेम्स में रख देते हैं. फॉर्म 3, अगर आप अपनी एप्लीकेशन को इंडिया के बाहर फाइल करते हैं, यू शुड हैव द नॉलेज ऑफ फॉर्म 3. फॉर्म 3 में आप वहां पे बेसिक डिटेल्स देते हैं कि सर मैंने इस एप्लीकेशन को यूएस में फाइल किया है इस तारीख को और इस एप्लीकेशन की ये स्टेटस है. तो आप यूएस, यूरोप, जापान, जर्मनी एटसेट्रा कहीं पे भी फाइल करते हैं तो आप ये फॉर्म 3 में बताते हैं I have filed this application in US on this date. This is the number, application number, publication number, whatever. This is called as Form 3, the foreign filing details. What is Form 5? Form 5 is declaration as to inventorship. जो भी inventors है वहां पर declaration देते हैं, सारे inventors के नाम होते हैं. This is called as Form 5, declaration as to inventorship. Now Form 18 is there, the last form. ये फॉर्म जब आप भरते हैं, whenever you file this form, your application gets into the examination process. जिस दिन आप ये एप्लीकेशन फाइल करते हैं, जिस दिन आप ये फॉर्म 18 फाइल करते हैं, from that day your examination process starts. Okay, and this exam is, say today you filed your application, today is the date 11th April 2022. तो 11 अप्रैल 2022 को आप अपनी एप्लीकेशन फाइल कर रहे हैं, तो 11 अप्रैल 23, 24, 25, 26, 11 अप्रैल 2026 तक आप फॉर्म 18 को फाइल कर सकते हैं. 48 मंथ में आप रिक्वेस्ट फॉर एग्जामिनेशन डाल सकते हैं. फाइन. दीज आर द 5 फॉर्म्स, इन्हीं की रिक्वायरमेंट होती है. फॉर्म 1 में आपकी बेसिक डिटेल्स होती हैं. फॉर्म 2 में आपके इन्वेंशन का पूरा डिस्क्रिप्शन होता है, ड्राइंग्स होती हैं, क्लेम्स होते हैं, एब्स्ट्रैक्ट होता है, टेक्निकल एडवांसमेंट क्या किया है उसके बारे में बताते हैं, एप्लीकेशन के बारे में बताते हैं, कोई न्यूमेरिकल एनालिसिस है उसके बारे में बताते हैं. आपको जितना अच्छे से आप ये बताएंगे फॉर्म 2 उतना बेहतर हम समझते हैं, क्योंकि फॉर्म 2 ही आपके इन्वेंशन की जान है. द सोल ऑफ योर इन्वेंशन इज फॉर्म 2. वहां पे आप अपने इन्वेंशन को फुली डिस्क्राइब करते हैं. फॉर्म 3 इज फॉरेन फाइलिंग डिटेल. अगर आप बाहर करते हैं इंडिया के फाइल सिमिलर एप्लीकेशन को, तो आप बताते हैं कि सर आई हैव फाइल्ड दिस एप्लीकेशन इन यूएस, यूरोप, जापान, जर्मनी एटसेट्रा. फॉर्म 5 में इन्वेंटर्स का डिक्लेरेशन होता है. एंड फॉर्म 18 द रिक्वेस्ट फॉर एग्जामिनेशन. व्हेनेवर यू फाइल दिस फॉर्म द एग्जामिनेशन प्रोसेस फॉर योर एप्लीकेशन विल स्टार्ट. अब आप देखिए गवर्नमेंट ने आपके लिए कितने सारे बेनिफिट्स दिए हैं. नेचुरल पर्सन कैटेगरी. नेचुरल पर्सन कौन होता है? हु इज नेचुरल पर्सन? मैं और आप क्या है? नेचुरल पर्सन है. मी एंड यू आर नेचुरल पर्सन. स्टार्टअप, स्मॉल एंटिटी और एजुकेशनल इंस्टीट्यूट, से योर कॉलेज. For them, the fees is just 5,600 rupees. 1,600 for Form 1 and for Form 18 it is 4,000. For the companies it is 28,000. So for the category of natural person, means me and you, say some student is there, they want to file application for them, or education institute. How an application comes for patent, you know? जब आप किसी कॉलेज में पढ़ रहे हैं तो you are using their resources. So you are the inventor. Your college will be the applicant. This is how a conventional application from a institute is filed. Your institute becomes the applicant and you are the inventor, and that's how your application is filed. So your institute is an educational institute, so the fees is 5,600 for you. There are 2 ways of filing your application. One is online and one is offline. This is our online portal. Now there is another advantage to some categories. If you want to process your application faster, there is something called as Expedite Examination. And the categories that are benefited from that are startup, small entity, and applicant is female. Say 5 students of Vaishnav college, they are filing an application and one applicant is female. So you will get the benefit of this expedite examination process. If you are filing expedite examination, you are satisfying this criteria that one applicant is female, or you are a startup, or you are a small entity, then you will get the benefits of this expedite examination process. Okay, you will get your first report within 90 days, and that first report is called as first examination report. पहले ही 90 दिनों के अंदर आपके पास एक रिपोर्ट आती है आपके इन्वेंशन की, उसको बोलते हैं फर्स्ट एग्जामिनेशन रिपोर्ट. पेटेंट एप्लीकेशन प्रोसेसिंग, कैसे आपकी एप्लीकेशन प्रोसेस होती है. हम बात करते हैं उन्हीं 5 बच्चों की. द सेम 5 स्टूडेंट्स ऑफ वैष्णव कॉलेज, दे आर वर्किंग ऑन समथिंग, they are designing something, they are developing something. Fine. If you are ready with your invention, say 60-70% you are ready, then you file your application today itself. You can update it within 12 months. If you are ready 60-70% with your invention, say today is the date 11th April 2022. So you can update your application till 11th April 2023. That is the advantage you are getting if you are filed today. If you are filing today. So provisional to complete, you get 12-month time to complete your specification, and you can update it a number of times. But the benefit you are getting is of 12 months. Or the priority hogi, the priority that you will get will start from today only. Your invention will get protection from today itself. Okay, but you will have the 12-month time leverage is there of 12 months. You can update it. Then your application will be published. You will file Form 18. You can file that Form 18 today also, or within 48 months from today. Okay, you file Form 18, fine. Your application will be examined by one officer like me. I am working on the post of Examiner of Patents and Design. I will prepare a report and put up to the controller. The controller will issue you the first examination report. And now you will get the time to reply to a report. How much is the time? Time is 6 months plus 3 months. You can extend it 4 times. You can extend it. 6 महीने आपको मिलते हैं reply करने के. You will always get adequate time, adequate opportunity to represent yourself. Just like in any other court, if there is a court case, you get a chance to represent yourself. So we will provide you a report called that first examination report. You will get the time to reply. Fine. Now you will reply. Your reply will again be examined. If your reply is satisfactory, your patent will be, you will get your patent granted. If your reply is still having some, if it is still not, you can say still having some objection, you replied to us, but your reply is not satisfactory, then we will provide you a hearing. Just like in courts, you get a hearing. We will provide you a hearing, and you can represent yourself. Okay. Hearing can be made, you can say online or offline mode. So this is the procedure we follow for a patent filing. Now, coming over to examination, how we check your application? There is formal examination. We will check keep proper timelines met हुई कि नहीं हुई है, proper fees payment है, yes, done. Technical examination, we check 3 things: novelty, inventive step, and industrial application. We will provide you a first examination report. First examination report में क्या होता है? आपने कुछ बनाया है, fine. हम ये कोशिश करते हैं कि आपने जो बनाया है उसके जैसे आविष्कार हमको मिले. हम लिस्ट अप कर देते हैं वहां पे, सर योर दिस फीचर इज मैचिंग विद दिस फीचर ऑफ दिस इन्वेंशन. आपके इस आविष्कार का ये फीचर इस इन्वेंशन से मिल रहा है, और योर इन्वेंशन इज सिमिलर टू दिस इन्वेंशन. आपका आविष्कार इस आविष्कार से सिमिलर है, मिलता जुलता है. तो ये आपको हम फर्स्ट एग्जामिनेशन रिपोर्ट में साइटेशंस प्रोवाइड करते हैं. और भी ऑब्जेक्शंस होते हैं, क्लैरिटी ऑब्जेक्शंस, वी प्रोवाइड यू ऑब्जेक्शंस. आप रिप्लाई करते हैं, आपके पास 6 months का टाइम है. ओके, इफ योर रिप्लाई सेटिस्फैक्टरी, वी प्रोवाइड यू अ हियरिंग. हियरिंग में फिर आपको 15 दिन का टाइम मिलता है, एंड आफ्टर दैट योर केस इज डिसाइडेड वेदर योर पेटेंट विल बी ग्रांटेड और रिफ्यूज्ड. हम आपके इन्वेंशन को कैसे स्क्रूटिनी करते हैं, देखिए, हाउ वी पुट अ स्क्रूटिनी ओवर योर एप्लीकेशन. हम आपके इन्वेंशन को पढ़ते हैं. वी अंडरस्टैंड योर इन्वेंशन with respect to your drawings, your numerical analysis, your tables, whatever. then we try to find out similar inventions in our database, or we have also, you can say, access to other countries' database. So under treaties, so we try to find similar inventions, and we check for the three things: novelty, inventive step, and industrial application. Provide a report to you, and that is called as first examination report. These are the timelines. If you file your application today, you can update it within 12 months. That is called as provisional to complete specification. You can file request for examination within 48 months. You can file reply to your reply to FER from the office. FER means first examination report, 6 months. If you are filing outside India, you should report to Government of India within 6 months via this Form 3. Form 5 is declaration to inventorship. If you are not interested in further prosecution of your application, you can withdraw your application within the 15 months. If there is a hearing provided to you, you get 15 days time to reply to objections. If you want to file an opposition for a patent, that is called as pre-grant opposition, you can file it before the grant of that patent. If you are filing a opposition to already granted patent, you can file, and it is called as post-grant opposition. You can file it within the 1 year of that grant of that patent. I will also share these slides with you so that you can have a know-how. Fine. Patent के लिए आपको प्रोटेक्शन मिलता है 20 years, ट्रेडमार्क्स इट इज 10 years रिन्यूएबल. जैसे आप लाइसेंस और पासपोर्ट को रिन्यू कराते हैं ना, वैसे इंटेलेक्चुअल प्रॉपर्टी राइट्स भी रिन्यू होते हैं. डिजाइन्स इट इज 10 years plus 5 years. Geographical indication 10 years plus renewable forever. Copyright, say you have written a book, so if your lifetime is 80 years, your book will get copyright protection for 80 plus 60, 140 years. That is the power of copyright. Plant varieties. Plant varieties are also coming under intellectual property. If you are designing a new plant variety, you can get protection for 15 or 18 years. Integrated circuit, if you are designing any new IC, you will get compulsory protection for 10 years. Now there is a quiz for you and you have to answer it. You can answer it in chat box or whatever. I will answer your doubts also later on. Okay. There is a quiz for you. In the question it is said, which type of IP protects the painting painted by artist? If there is some artistry work, a painting is there, which type of intellectual property protects any painting by any artist? You can answer in chat box or you can unmute yourself if you have the facility. Copyright is the correct answer. All the literature work, all the artistry work, painting, sketching, drawing, films, music, scripts, sound, you can say sound recording, sound mixing, all these things come under copyright. Next is, if there is some fashion designer and they are creating some intellectual property, it will be protected under what? Registered design is one answer, and there can be two more answers. If there is some pattern on this cloth, you will get design registration, fine. Okay. But if you are putting a logo here, it will come under trademark also. And also, if you are putting some painting of some artist on it, it can come under copyright also. So for this type of intellectual, for this type of creation by a fashion designer, you can have three answers: a design or a pattern, a trademark might be there for a logo. Of if you are putting a painting of some artist on this cloth, it can come under copyrights also. If you are developing some advanced disc brake for some bike, it will come under which category? Advancement is happening in disc brake. Patent, correct answer, because you are talking about technical advancement. Whenever we talk about technical advancement or invention or developing some model, instrument, device, all these things come under patents. Which of the following is geographical indication? इनमें से कौन सी चीज भौगोलिक उपदर्शन है? करेक्ट. What does a trademark protect? ट्रेडमार्क क्या प्रोटेक्ट करता है? लोगो, नेम्स एंड ब्रांड्स. फाइन. पेटेंट का टर्म कितना होता है? How much is the term of patent? 20 years. Correct. आपने कोई स्टोरी लिखी है and you want to create and sell copies of it. You want to create more copies. Okay. And you want to sell such copies. It will come under which category of intellectual property? Copyright. A cricketer, they are doing some branding of their clothes. Fine. It will come under which category? You can take example Yuvraj Singh, YWC, fashion. Okay. So these things come under which category? Trademark. Correct answer. Last question for you. If there is some product, say there is some device and there is some main product and they are developing some new technology and that is improving that main product. We are talking about technology. We are talking about technical improvement. We are talking about advancement. It will come under patent. Fine. Now there is a little, you can say a small animation for you of 1 or 2 minutes, and that will explain you that how intellectual property rights are there everywhere near you. Ma'am, is the sound of audio is fine?
Yes, yes.
Fine. There is a geographical indication on the cloths. Fine. Some famous, it might be a, you can say a geographical specialty, a cloth designed by some local artist. And you can see the copyright involvement is there because there is a book he is reading. I am stopping at the slide because you can see that for the technology part, you can file a patent. For the trademark, you can have a logo on the phone. And for the protection of your songs, programs, softwares, or the literature work associated with the phone, you can file a copyright protection. And for the outer appearance part, you can register a design. Now you can ask your doubts. The session is over from my side, but the doubts we can handle now. So you can unmute yourself, or you can just I am finding at 2-3 questions, so I will just check with these questions first. Yes,
Thank you very much, sir, for sharing your reflective knowledge with us, which will be surely very helpful for students. It looks like we have some questions.
Yes, ma'am. What if
The
we innovate? Yes, ma'am.
first question is from Vinny Joshi. She is asking, what if we innovate something and its design is similar to some other product, but the concept is different? Is there any chance it can get copyrighted?
First of all, there are this was the question asked at the beginning of the session. First of all, this question will become technically wrong because you are talking about innovation, okay? And you are innovating something, you are creating something new. We're talking about invention. So invention will be registered as patent, okay? If there is some literature work, it will come under copyright. So if you are developing something, you can say you have, and you are talking about design also now at the same time. Design is something new, a different thing. For the technology part, you can file what? A patent. For the literature work, you can file a copyright. And for the outer appearance part of any object, you can file a design registration. These three things are quite different. Not talking about your query in mind, it is saying you are developing, say, similar invention. Some invention is already existing and you are developing a same invention, but you are using a different concept. If you are creating the same thing, fine, but it should have the technical advancement. Say it should having some efficiency better than the previous invention. It should have the efficiency in terms of parameters, might be time, maybe a factor, a delay, might be cost. So there should be some technical advancement might be there. Okay, there should be some technical advancement with respect to the previous invention. No doubt you are developing the same thing, but it should have some advancement. Advancement can happen. जैसे कि आप कंप्यूटर प्रोग्रामिंग में बात करते हैं, कंप्यूटर सॉफ्टवेयर, कंप्यूटर जो स्टूडेंट्स हैं, वहां बात आती है टाइम की, प्रोसेसिंग टाइम की बात आती है. तो जब आप सेम चीज पे ही पहुंच रहे हैं, किसी ने कुछ बनाया है एंड यू आर क्रिएटिंग द सेम थिंग, it will not get patent. It will get, it can get the, you can get the patent for it, but you should have some technical advancement. कुछ तो efficiency हो. आपने जो दूसरे ने बनाया है सेम चीज बना दी है, बट वो टेक्निकली कैसे बेहतर है, टेक्निकल एडवांसमेंट कितना है इन टर्म्स ऑफ, इट मे बी यू कैन से टाइम, डिले, पैरामीटर्स और रिसोर्सेस. सो दैट्स हाउ यू कैन रजिस्टर. Yes, ma'am. Second question.
Yes, the second question is from Kanishk Deswal. His question is, in which category IS or ISI number will fall? And if ISI or IS number on a product has not been identified or say it is fake, then what action we should take?
See, we are from Intellectual Property Office, so our area is concerned with trademarks only. Here, means patent, design, trademark, copyright, and geographical indication. So if you are talking about a product, whatever we are concerned with trademark only. A trademark, if you are choosing, it should be different. ऐसा ना हो कि आप नकल करें एडिडास का, एबीबास करें. This should not happen. So whenever you are choosing a trademark, जब आप एप्लीकेशन फाइल करते हैं कंपनी के लिए ट्रेडमार्क की, तो आप कोई डिजाइन अपना नाम सजेस्ट करते हैं, सर वी आर थिंकिंग अबाउट दिस नेम, काइंडली गिव अप्रूवल. इस तरीके से एप्लीकेशन आती है कि यू आर सपोजिंग यू वांट दिस नेम, सर हमको ये नाम चाहिए, एबीसी डिजाइन्स. एबीसी डिजाइन अगर हमारे सिस्टम में नहीं होगा तो आपको एबीसी डिजाइन का रजिस्ट्रेशन मिल जाता है. अब आप बात कर रहे हैं यहाँ पे ISI एंड अदर मार्क्स, दीज आर dealt by other departments of government and not us. So you can just do Google and you can search what is their procedure. Yes, ma'am.
Our next question is from Parul Chauhan. In animation film production field, if we work on a film, can someone work on the same concept to make a different one?
See, if you are using the same, here we're talking about animation film, so it will come under copyright. But if you are copying their script, then it should not be done. Okay, because script is a part of copyright. So you are taking about the concept. If the concept is same, if there is no difference in concept, means you are just copying the same script, and you might be creating a movie in Telugu, or you can say Malayalam, or you can say French or Spanish on the same script. This should not be done. And if you are doing this, it can be done. Also, you need to take permission from that original person. Say, मैंने कोई हिंदी या इंग्लिश में कोई मूवी बनाई है और आप सेम कॉन्सेप्ट पे कोई मूवी बना रहे हैं, तो आपको मुझसे परमिशन लेनी पड़ेगी. फॉर एग्जांपल, यू कैन टेक द एग्जांपल ऑफ ऑल इज वेल मूवी. It was created on the novel of Mr. Chetan Bhagat. So the film producer might have taken the permission from Chetan Bhagat, sir, I am creating a movie on your novel. And they might be having some agreement also regarding the commercial aspect, because the content is of Mr. Chetan Bhagat. Content किसका है? मेरा है या चेतन भगत सर का है, तो आपको मुझसे या उनसे परमिशन लेनी पड़ेगी. You should take always the permission of the original person if you are creating something out of it. Otherwise it is a copyright violation. क्योंकि स्क्रिप्ट उनकी है, मेहनत उनकी है, आप क्या कर रहे हैं? नकल कर रहे हैं. You are copying it, you are stealing their content. So you should always take permission. If you are using any other content for your purpose, you should always take permission. Yes, ma'am.
And next question is from Shubham Singh Gujar. A patent done by an employee or student of organization, does the organization also own that patent too, as the person done work using the resources of organization?
Yes. Generally, होता क्या है कि whenever we talk about any patent application, we are not concerned about who is the applicant, but एक conventional procedure है. एक convention जो हम देखते हैं ऑफिस में, जैसे for example, some institute is there, say Vaishnav Institute is there, okay, and Vaishnav College they have filed an application. So college ने तो उसका आविष्कार किया नहीं है. आविष्कार किसने किया है? Inventors ने. Fine, but they were using the resources of institute. So in such cases, how the application is filed by any applicant, what they do, your college becomes the applicant. आपका college बन जाता है applicant, and the students and faculty members who are working on it, they become the inventors. There are two things in patents. One is inventor and one is applicant. So patent office को इससे कोई मतलब नहीं है कि इन्वेंटर कौन है, एप्लीकेंट कौन है, बट आपको एक कन्वेंशन में बता रहा हूँ. कन्वेंशन कैसे लोग फाइल करते हैं. कभी कभी एप्लीकेंट में इंस्टीट्यूट भी होते हैं, कॉलेज भी होते हैं, और साथ में उनके साथ कोई यू कैन से कोई इन्वेंटर का नाम भी होता है एप्लीकेंट में. या कभी कभी क्या होगा कि इन्वेंटर सिर्फ स्टूडेंट्स और फैकल्टी मेंबर्स हो सकते हैं और एप्लीकेंट हो गए आपके कॉलेज. सो there are various conventions that are followed, so it depends on how there is आपके इंस्टीट्यूट में, आपके कॉलेज में कैसा सेटअप है, what type of setup you have. But generally it happens that in applicant there is college, or there might be some student or along with the college, and in the inventor the students or the faculty members are there. And also we don't check who is the student or faculty members. That's why I am saying कि आविष्कार करने वालों में कौन होंगे, या तो फैकल्टी मेंबर होंगे या स्टूडेंट्स होंगे. दिस हाउ वी सी एन एप्लीकेशन. जैसे हमारे पास जो और इंस्टीट्यूट के एप्लीकेशन आते हैं, कॉलेज के एप्लीकेशन आते हैं, वो इस तरह से आते हैं. यस मैम.
Sir, our last query is from Dr. Nisha Garg,
Yes, ma'am.
Head of Department Sardar Vallabhbhai Patel College, Mandleshwar.
Yes, ma'am.
Her query is, myself, Dr. Nisha Garg, I filed provisional patent on 17 June 2020, application granted 1st July 2020, and application attorney hired by us. We applied for early publication and expedite examination now. 21st Jan patent published, and 14 March we got. Now question is that how much we have to pay for first examination report? Answer
Okay.
given by
First of all, it is written here that you have filed an application for 17 June 2020. An application granted. Application grant नहीं हुई होगी मैम यहाँ पे. अगर आप अपने आप को अनम्यूट कर सकती हैं, अगर आप अवेलेबल हैं तो यू कैन कॉन्टेक्ट मी वर्बली. कुछ और हुआ होगा यहाँ पे. 17 जून को फाइल हुई है और 1 जुलाई को ग्रांट नहीं हुई होगी. कुछ और हुआ होगा. ठीक है, आपने किसी पेटेंट अटॉर्नी को हायर किया, ओके. आपने अर्ली पब्लिकेशन के लिए फॉर्म 9 फाइल किया होगा, दैट्स फाइन. फिर आपने एक्सपेडाइट में उसको कन्वर्ट किया होगा. 21 जैन को पेटेंट पब्लिश हुआ, फाइन. 14 मार्च यू गॉट सम क्वेश्चन. अच्छा, पहले आई थिंक you might have filed a new a normal application, and now you have converted into expedite application. So now you are saying that how much you have to pay for your attorney. So let me tell you one thing, that we are government of India, and we have nothing to do with attorneys, whatever they are charging you. But for converting a normal application to expedite application, there is 4,000 fee you need to pay. Okay, that is the government fee. That is the part of your procedure. But how much they are charging you, you can consult with them. क्या होता है, जैसे आपने एक्सपेडाइट एग्जामिनेशन फाइल किया, ओके, एक्सपेडाइट एग्जामिनेशन आपने फाइल कर दिया, फाइन, माइट भी आप स्टार्टअप कैटेगरी में है या स्मॉल एंटिटी में है, और यू आर एप्लीकेंट, फीमेल एप्लीकेंट, फाइन, तो आपको वहां पे अगर आपने फर्स्ट टाइम ही एक्सपेडाइट एप्लीकेशन फाइल किया तो यू नीड टू पे 8,000. बट अगर आपने कभी नॉर्मल एप्लीकेशन फाइल किया और आप बाद में उसको एक्सपेडाइट में कन्वर्ट कर रहे हैं, तो नॉर्मल एप्लीकेशन की फी होती है 4,000. तो अगर आप उसको एक्सपेडाइट में कन्वर्ट करते हैं तो आपको बैलेंस जो होता है 8,000 माइनस 4,000, वो 4,000 ही पे करना होता है. एक्सपेडाइट एग्जामिनेशन के लिए आपको 8,000 फाइल करना होता है, लेकिन आपने नॉर्मल एप्लीकेशन फाइल की तो आपने ऑफिस को 4,000 तो पेमेंट कर दिया. अगर आप उसको नॉर्मल को एक्सपेडाइट में कन्वर्ट करना चाह रहे हैं अब, तो आपको जो बैलेंस है 4,000 वो पे करना होता है. लेकिन जो अटॉर्नी है वो आपको कितना चार्ज कर रहे हैं, इट इज लाइक जस्ट लाइक वॉट एवर यू हैव एजेंट्स आउटसाइड फॉर योर वर्क. गवर्नमेंट फी इज दिस. तो ये आंसर तो आपको वही कर पाएंगे कि कितना.
हेलो,
यस मैम.
आर यू हियर मी सर? हेलो,
यस मैम.
मेरा क्वेश्चन ये है सर कि फर्स्ट एग्जामिनेशन रिपोर्ट का जब हम आंसर देते हैं तो उसके लिए जनरली कितना कॉस्ट होता है एज अ अटर्नी?
मैम, एज अ अटॉर्नी आई कैन नॉट से, बिकॉज़ आई एम नॉट एन अटॉर्नी. आई एम patent office Mumbai. I am officer, yes, working on the post of examiner of patents and design. This is all things the private business, and office just provide them certification that you can work as patent agent.
Okay.
After that, whatever they are charging you for FER reply, office does not charge any fees.
Okay.
What happens that yes ma'am,
attorney, for attorney it's only,
yes, it's from the side of attorney. What happens that, let me tell you one thing, that we are filing an application of patent on our own. It's okay. You will deem your application on your own. But if you are not able to file your application, you can hire a agent.
yes,
For patent, it is called as patent agent. Office just take 2 times fees. One for form 1 and one for form 18. And they are 1,600 and 4,000 rupees. Total application fee is 5,600. But if you want to expedite your application, you need to pay an extra 4,000. That's it.
Okay sir, thank
For
you.
early publication, there is form 9.
Yes,
And
I
whatever
feel
the office fee you can check. Yes ma'am.
application already
Yes, ma'am.
हो चुका है सर, बस लास्ट प्रोसेस हो रहा है. Because one more
Yes, ma'am.
thing, object, that is NBA application also filed by me, and the NBA
Yes ma'am.
acknowledge,
NBA.
I got the NBA acknowledge applicant number also, and
Yes, ma'am.
there is some information I have to give them, then file the answer the first examination report.
Correct ma'am. Correct ma'am. Because some applications you require NBA approval, and once you
Yes.
get the approval, then only the process of grant will happen.
Okay,
Or
बस
refuse, whatever. The case
हाँ,
will be
ये
decided once you
last
get the
process
approval.
बचा है सर बस अभी.
Yes ma'am.
जी जी.
Great ma'am.
Thank you. But the webinar conducted by you is very fine, sir.
Thank you
It's
ma'am.
really nice. Thank you, sir. Thank you so much.
Thank you ma'am.
Thank you, sir. To express a word of appreciation and gratitude, we have with us Dr. Vinayak Vishwakarma, Assistant Professor, Sri Vaishnav School of Management.
Hello, I think it was a very wonderful session, and there are lots of information that has been shared. Actually, I think in a business domain or in an engineering domain, students should know at the very early stage so that they can protect their intellectual property at the very beginning stage, right? So all the contents and the things which we created by students are so the session was very informative. So on behalf of the entire team of this particular event on IP awareness and entrepreneurship development cell, I wish all the students a beautiful journey towards creating various IPRs. And I also thank our special speaker for today's session, Mr. Arpit Jain, for delivering such a wonderful session and giving a small example so that student can relate with that, and we literally have understood all this part. So once again, all the student members and teams and entire visionary who given us motivation, Dr. Mandal sir, Namit Gupta sir, and all our team of EDC who has made this event possible. So on behalf of entire team and the student community, I'll thank you all, and thank you, Mr. Arpit, for giving this a wonderful session. Thank you very much.
Thank you, sir.
Hello, am I audible? Yes.
Thank you, sir. And now let us all rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you and have a nice day to all of you.
Thank you, ma'am. Thank you for beautiful ending of this session by having a national anthem. Thank you, ma'am.
Thank you, Arpit. Thank you.
Thank you, Arpit sir.
Thank you, ma'am.